Doktor dah sampai. Alamak. Okay, guys, please take a look at this video first and we will discuss about this question later.
Jom, let's go. Miss, what happened, Miss? Tell us your story. This garden used to be my favorite place. I spent years taking care of it. Now, look at it now. It's not beautiful anymore. My plants are dying, and my koi fish did not survive. What can I do? Please help me. I need your advice.
Ali, the soil here is unstable. The plans clearly show the risk of collapse.
We don't have time for delays. Just secure it and keep moving.
Ever.
Look out! Here comes a big wave!
Let's go again. A breach in the underground tank allows toxins to seep into the environment, flowing downhill and threatening the nearby neighborhood.
So, based on this situation, what is the main issue here? Doktor, saya. So, based on this question, I think there are two issues here. So, the first one is whether Ali, as the operator of the water theme park, is really liable under the rule in Reliance against Fletcher for the damage caused to Farah's house, her garden, her koi pond, and contaminated soil due to the escape chemically treated water flow downhill to the neighborhood. So the second issue is whether Ali owed a non-delegable duty of care to prevent harm arising from the escape of chemically treated water that damaged Farah's property. Alright, thank you so much, Shu, for answering my question. So, based on this situation, what are the law that is applicable to this situation? Can I answer, madam? Me.
Sure, you have answered already. May I choose Nisha to answer this question?
Okay, thank you, madam. So actually, this case, law principle come from the Ryland against Fletcher. So in this case, Ryland built a reservoir and the water later escaped and flooded Fletcher coal mine. So even though Ryland was not careless, the court still held him responsible. So the key point is that if someone keeps something dangerous on their land, they must make sure it doesn't escape. So there are 5 basic elements, which is the thing stored must be dangerous if it escapes. Second, it must be kept intentionally. Third, it must be actually escaped. And then the damage must be foreseeable, and the use of Scotland must be a non-natural. But madam, can I give a recent example in Petronas gas berhad against DW Industry?
Yes, you may.
Okay, so in this case, DWZ Industry failed to manage its exudate waste properly and the chemical leaked into the ground and reached the Petronas gas line and damaging an underground gas pipeline. So the court held that DWZ was liable, showing that companies dealing with hazardous substances are responsible if those substances escape and cause damages.
Thank you, Amisha, for answering my question. So, can anyone give any two recent cases that can be applied in this situation?
Sophia, you try now. I'm not sure.
I think I want AMNI to answer this question.
Okay, madam. Madam. The first case is Abdul Aziz bin Awang versus Tenaga Nasional Berhad in 2020. The plaintiffs were residents of Bertam Valley, Cameron Highlands. Tenaga Nasional Berhad (TNB) owned and operated the Sultan Abu Bakar Hydroelectric Dam, and on 23 October 2013, after continuous heavy rainfall, TNB released a large amount of water from the dam, causing severe flooding downstream. The floods destroyed homes, businesses, agricultural land, vehicles and public facilities, and resulted in loss of lives. The plaintiffs alleged that TNB was negligent in failing to install proper water level monitoring and warning system, and relied on the principle in Riders versus Fletcher for the damage caused. The High Court held that TNB was liable. The court found that storing massive volume of water in the dam amounted to a non-natural use of land, and that the water was a thing likely to cause mischief if it escaped. The escape of water and the resulting damage were reasonably foreseeable, satisfying the requirements of strict liability under the Riders versus Fletcher. Accordingly, TNB was ordered to compensate the plaintiffs for their losses. And the second case is in Jala versus Shell International Trading. The claimants were residents of Niger Delta whose land and communities were affected by an oil spill from a pipeline owned by companies within the Shell group. The oil was released in a single incident but remained in the soil and rivers for many years, continuing to pollute the area and interfere with the claimants' use and enjoyment of their land. The claimant argued that because the oil was still present and causing harm, it amounted to a continuing nuisance, allowing them to bring a claim despite of passage of time. Then, the UK Supreme Court rejected this argument. The court held that a one-off escape of a harmful substance that causes lasting damage does not constitute to a continuing nuisance. Instead, the cause of action arises at the time of initial spill. The court distinguished between repeated or ongoing acts and the continuing consequences of a single event. It also confirmed that the land contamination amounts to a physical damage and that liability depends on defendant's control over the substance at the time of its escape.
Very long explanation, but a good case to apply. Okay, from what your friends have told and explained to us, can you guys apply the laws and the case based on the situation? Does anyone want to try?
Can we try? I'm not sure what answer is right. I don't know. How about you? Sebetul.
Doktor, Sophia nak try. Doktor Sophia.
Madam, can I try to answer the application?
Yes, you may.
So for the first issue, madam, in application, when Ali stored a dangerous substance in his land, The underground tank contained a massive amount of recycled water that mixed with strong chemicals. So, such chemically treated water is likely to cause harm if it escapes. As in the case of Petronas Gas Berhad against DWZ Industries Sdn Berhad and another, where the acidic industrial waste was considered dangerous and highly likely to cause damage once it escapes. So the damage is foreseeable because Ali had been warned by the contractor that the soil was unstable and needed reinforcement. So despite this warning, Ali insisted on proceeding and finishing the project quickly. So therefore, it was reasonably foreseeable that the tank would crack and cause the chemically treated water to escape, especially the water theme park located on the hill above the residential area. So despite this warning again, the project was allowed to proceed rapidly in order to meet the peak school holiday season. So therefore, when Ali constructed the underground tank on a hill overlooking a residential area, it would ultimately increase the potential risk of harm if any failure occurred. It was reasonably possible that any escape of chemically treated water would flow downhill and cause damage to neighboring homes. So this element of foreseeability was recognized in the case of Abdul Aziz bin Awang against Tenaga Nasional Berhad, where downstream flooding occurred following the escape of a large volume of stored water and strict liability was imposed. So there was a clear escape of the dangerous substance. Cracks formed in the underground tank after minor tremors, allowing chemically treated water to flow downhill into the residential neighborhood. It was clear. The water entered to Farah's property, damaging her garden and koi pond and contaminating the soil. So this constitutes an escape beyond Ali's control, fulfilling the escape requirement under the case of Rylance against Fletcher. So, Madam, Ali also used his land on a non-natural manner by storing large quantities of chemically treated water for commercial and profit-making purposes. Such use of land is considered non-natural because it created an exceptional and abnormal risk to neighboring landowners, as affirmed in the case of Petronas Gas Berhad against DWZ Industries Sdn Berhad and another. Farah hereby suffered physical damage to her property as a result of the chemical contamination. So this form of pollution is recognized as physical damage under the case of Jala against Shell International Trading Limited, where contamination of land was held to constitute actionable damage. We're moving on to the second issue, madam. So, Ali cannot avoid liability by blaming the contractor who constructed the tank. The storage of chemically treated water involves an inherently dangerous activity that poses a high risk of harm if adequate precautions are not taken. So, as the occupier and the operator of the land, Ali retained control over the activity and derived commercial benefit from it. Ali therefore owed a non-delegable duty of care to ensure that reasonable precautions were taken to prevent harm arising from the escape of the dangerous substance, which is the chemical water. His decision to disregard professional warnings about the unstable soil demonstrates a failure to discharge that duty. So the liability remains with Ali regardless of the involvement of an independent contractor. That's all from me, madam. I don't know if I'm right, but that's my answer.
Thank you, Sophia. I think that is such a good application.
Thank you, madam.
That's all for today. Thank you, everyone.
So madam, wait, what about the conclusion?
The conclusion? Oh, the conclusion.
Yes.
So, in conclusion, Ali is legally responsible for the damage suffered by Farah because all the elements under strict liability are satisfied. So, Ali is responsible to compensate Farah.
Okay, madam. QR?
Doktor,
Oh, QR.
QR